Good afternoon, everyone. My name is Angela Anikwe Egine. I'm an associate at Omaplex Law Firm, and I'm your facilitator for today. So it's exactly 1 p.m. and we're about to commence. But before that, I think we should give a few minutes for some persons to formally join. Hello, everyone. Welcome once again.
Good day, ma'am.
So, good day, everybody. Good day. Please, I would love us all to make use of our emojis when we want to react. When the speaker is speaking, make use of your emoji. Thank you so much. Thank you, Abdul Salam. I don't know if you guys remembered last week I anchored you on sport law, and I know you guys had a very wonderful session. I actually saw that a lot of you got interested in sport law, and actually sport law is a very good area of law, and by the virtue of the fact that it's an evolving area in Nigeria, I know a lot of you developed interest, and I hope you guys later reached out to the speakers and so you guys have started following them up in on their LinkedIn profiles and their pages and all that. So guys, I'm so happy to anchor or facilitate you for today again. And in today's section, we are going to be looking at technology and data protection. Although our topic is going to be on understanding the concept of technology and data protection in Nigeria. Tech law is a renowned area of law in Nigeria, and a lot of you are interested because the world is actually evolving. So before we commence, like you guys know, I'm the person that I really love feedback. So I would love to get feedback on last week's section. I understand that last week you had a section on entertainment and fashion law. Yes. Adeze. Adeze, yes, I can see. But please, when you unmute yourself, I would love every other person to remain muted. Please. When you unmute, thank you, Akuchi. Akuchi, I'm seeing you. Okay, Abdusalami, but wait, we're all going to take it one after the other because I actually love feedback because I want to be sure each and every one of us have been following the classes. Yes, please, when you unmute yourself, when I ask you to unmute yourself, I would love every other person to remain muted because I wouldn't want the classes to be rowdy. Thank you very much. So the first person I saw the hand raised was actually Adeze. So Adeze, you can unmute yourself and give us a brief recap on what you learned on entertainment and fashion law.
Okay, good afternoon, everyone. My name is Adeza Nicolo from Nnamdi Azikiwe University. So, the last class we had by Sir Optimist Ibukun was on entertainment and fashion law. And I would say that the class was very, very engaging and interactive. He was giving even more advices on other areas of law and not just entertainment law. He was giving us advices on we should be practical, we should be curious, we should always, venture on learning a lot of skills and not just, being specific to only your law areas. He also talked about the fact that he's a graphic designer and the fact that he's using even the skills, other outside area skills that he has to even, broaden himself, that there are thousands of lawyers that you have to, have something in you that can make you stand unique and also, stand out in the competitive section. So by that, he said we have to be curious. We always need to if we have questions, we should always, ask, and we should always connect with a lot of people. And he said that in this area of entertainment law, if you're going to be a lawyer in this aspect, the one thing that can help is, for one, you need to be attending conferences, meet people, connect to a lot of people. And he also talked about the fact that you also need to have other ideas of contract law, how to make contracts and every other thing. Then you also said that you need to be following trends because this is something like entertainment and fashion. So you need to always be updated on any celebrity lives or anything. You just have to, be updated. So you also talked about the fact that you having known that this entertainment and fashion law is sometimes related to, internet. You also have to, be technology, oriented. Then you talked about why this entertainment law really matters. He said something that actually stood out for me, and that's something that I really remembered. The fact that he said that entertainment law is the key areas that actually safeguards the creativity and authenticity of people's ideas, in the sense that it helps to protect and give each person's music or any area of socialization a genuine mark, something like patent rights, copyright, trademarks, and it's entertainment lawyers that helps to safeguard your work. So it helps to make sure that people actually actualize that their dreams of whatever innovation that they actually have. So you also talked about the fact that the backbone of this creative economy entertainment law is you have to the backbone of it is actually intellectual property. So you also talked about the fact that the key areas of entertainment law is filming, talked about content creation, he also talked about the fact that even sports, is also part of entertainment. So someone who's a sports law can also, be an entertainment lawyer. Talk about copyright, trademarks, and the fact that entertainment lawyers helps to, brand your ideas or your product. So that's just one of the key takeaways I took out. Thank you very much.
Thank you very much, Adeze. That was really wonderful. And I can't even see you guys reacting. Clap, give a virtual clapping, please. React with your emojis. This was really beautiful. Adeze, it showed that you all have been actually following the classes. I'm very much impressed. So I would love a second person to give me a recap on your ADR class that was anchored by Barrister Wendy. So I would love someone to give me a brief recap. Let's be quick about it. So I will take Abdusalam. Please unmute yourself and everyone, the person mute yourself.
Because we're position area under this for on area, I think I don't basically remember the name, but basically what the person as they explained the ADR and the application of ADR in some sectors, such as he explained that arbitration, mediation, and conciliation, and also where they are mostly used. He explained that arbitration is mostly used in all these commercial and investment agreements, while mediation is mostly used in family dispute matters. And also, she also went into picking each of them one after the other, and then arbitration as where the parties resolve their disputes. The third party known as an arbitrator who gives a binding decision, which is known as an out. And also, she went to define a mediator as as where the disputing parties submit their disputes to a third party, which is known as a mediator. But the difference, he also elaborated on the difference between a mediator and a conciliator or conciliation by saying that, yeah, the mediator just makes sure that the parties or facilitates communication to ensure that the parties meet an applicable settlement. However, conciliation is just where the parties submit their disputes to a third party named mediator, who also suggest solutions or suggest amicable solutions to the parties. And basically, she just terms how we can use this dispute resolution mechanism, this alternative dispute resolution mechanism to some areas and some emerging areas such as technology law, artificial intelligence law, and some other new emerging areas. Let me conclude by saying that she basically defined alternative dispute resolution by saying that these are mechanisms that we use as the court has even she said something about the court changing the alternative dispute resolution. That's the as but that it is reporting the litigation and the normal court system. So ADR just basically means that we are going outside court, not the normal litigation system. So that will be all.
Thank you so much, Abdul Salam. Please, yes, thank you, Esther. Please keep clapping. Thank you, Mariam Ibrahim. Thank you. Please keep clapping. It shows that yes, you guys have been following up with the classes. So I want another person to speak on sport law. That was the one I facilitated. Thank you so much, Abdul Salami. So I want someone else to speak on sport law. That was one I facilitated last week. So just briefly, very brief. I Oyin Damola. I'm so sorry if I murdered your name, please. Oyin Damola, can you speak to us? Thank you.
You've identified me as raising my hand, but I'm still here.
I'm so sorry about that. I'm really sorry. Since I've already called Oyin Damola, maybe Oyin Damola should speak to us. Thank you. All right, because Oyin Damola is not ready, so can you go ahead?
All right. Good afternoon, ma. Good afternoon, everybody. Well, about sports law, there were two facilitators. I can particularly remember one person's name, and that's Barrister Israel. Said he's licensed and all. So he was telling us that the sports industry, it's more like on a world of its own. So we should not like more or less take the principles of litigation and put into sports law. So that's one of the fundamental things he said. He said that it can be more regulated. Sports law you can see a bit of principles of corporate governance in it a bit. There is not a lot of litigation. Because the kind of dispute resolutions that are used is more of the alternative dispute resolutions, such as negotiation and conciliation, and also arbitration. So he mentioned that one of the courts that one of the courts that I go to, the court of arbitration for sports, which is CAF, and I took that home with myself. He told us something about a certain term. He said lex sportia, I think, which he said was more like body of laws that come from international sports organizations and arbitration tribunals, that come together to now make it form like law that govern sporting activities. He said that the standard of proof, it's not really reasonable that, but the reasonable that comes in only when there are like criminal issues in the sport, such as doping and all. But when it's on contract on or normal civil issues, it's more of a balance of probability. So you see that coming through like in contracts and all that too. Then additionally, he mentioned something about he was saying something about the different aspects, the different aspects of um, different aspect a lawyer or someone who is a legal practitioner can venture more into as regards to sports law. And that was where he was talking about someone being more known with company, working with such like laws of the UEFA, laws of teams as a compliance officer in euros, right? And then there's commercial practice where you could also come in negotiating deals for the players and the clubs, and also drafting player contracts. You should also come there in image rights when they are using, like, for example, in FC 26 now, image rights of the play of such games or video consoles. This is it. Then intellectual property, board casting, and sport immigration, where players can also, I think he mentioned the situation where if you're not playing for your home country, you cannot be featured in a Premier League match in England, particularly. So that's an example of what he was mentioning there. So he's also mentioned the dispute resolution chamber, the solidarity mechanism in football contracts that must have terms in it, and that the lease period is actually 6 months, but the most he knows of is 5 years. So this is basically, some of the things. These are basically some of the things I took home from the sports law they hosted by two speakers, but particularly the name I can remember very well is Barrister Israel. Thank you very much, ma'am.
Wow. Akuchi, this is beautiful. Thank you so much. Thank you so much. Thank you so much, everyone that spoke. I really appreciate this. Thank you so much. Thank you, Eniola, for clapping. Thank you, everybody, for clapping. Thank you, Miriam, Ibrahim, Abdusalam, Adede. Thank you, everybody. Thank you, everyone that spoke. So, guys, I'm delighted to welcome you all in today's section once again, in today's OVIP section. So, as we continue to explore the many facets of modern legal practice, one area that is increasingly critical and evolving rapidly is the intersection between technology and data protection. So in today's digital world, data is one of the most valuable assets and also one of the most vulnerable. So from cybersecurity threats to privacy regulations, the legal landscape surrounding data protection is constantly shifting. So as future legal professionals, it is essential that we understand how technology is reshaping not only how we practice law, but also how we protect sensitive information. So to guide us through this crucial topic, so we're privileged to have in our midst a wonderful speaker, who is going to pour upon us his wisdom of knowledge. Guys, before we introduce our speaker, I would love to read the profile of the speaker. So I want us to fasten our seatbelts. Let us get ready. Get your papers and your pen. Get ready because today's section is going to be fantastic. So I'm going to introduce our speaker. Our speaker is no other person but Olugbemi Johnson Abiola. Olugbemi Johnson is a legal practitioner. Olugbade Johnson, sorry. I am so good at murdering people's names. I'm so sorry. Olugbade Johnson Abiola is a legal practitioner. He's a legal associate in dispute resolution and litigation department at Omaplex Law Firm with a growing specialization in technology law and emerging legal trends. He holds an LLB from Ambrose Ali University and was also called into the Nigerian bar after completing his legal training at the Nigerian Law School Kano campus. So at Omaplex Law Firm, Olugbade combines his litigation expertise with a keen interest in the legal implications of technology. He provides strategic legal advisory to clients on data protection, cybersecurity, digital compliance, and tech-related disputes. His role involves drafting court processes, developing case strategy, conducting in-depth legal research, and representing clients in civil, commercial, and tech-driven disputes. Driven by a commitment to staying ahead in the evolving intersection of law and technology, Olugbade continues to expand his competence in areas such as AI regulation, fintech compliance, and digital rights litigation. Ladies and gentlemen, to guide us through this crucial topic, we're privileged to have us a speaker who brings both deep insights and practical experience in the field of technology, law, and data privacy and regulatory compliance. Please join me in welcoming our speaker who will be speaking on technology and data protection. And the topic is going to be on understanding the concepts of technology and data protection in Nigeria.
Hello, good afternoon, everyone. Can you hear me?
Yes, sir. Good afternoon, sir.
All right. Good afternoon,
Yes, sir. We
everyone.
can
Okay. And you can see me as well.
Yes,
Yes,
sir.
sir.
Yes.
Okay. So actually, for the purpose of this OVIP session, I'll be turning off my camera, but I just thought it wise to show you guys my ugly face. So like the lady, Miss Angela said, my name is Olugbade Johnson Abiola. Though she murdered it, Olugbade Johnson Abiola. And don't mind all those plenty English that she used in introducing me. You know, we are in profession together. We are all learning. So it is a promise, or rather hoped, that by the end of the lecture, we would be able to get one or two from our discussion. So once again, I want to welcome each and every one of you to yet another VIP session. So like I said, I'll be turning off my camera. At least you guys have seen me. So let's go through that now. So as you already know, today's topic is understanding the concept of technology and data protection in Nigeria. So the learning outcome, we are hoping that by the end of the discussion, we should be able to have an understanding of this following concept, which is one, understanding the basics, which comprise of definition and categories of data, and of course, relevance in the legal profession, as well as data protection versus data privacy. They are both two concepts that are used interchangeably, although they mean quite different things, right? Then, of course, we would look at data privacy best practices. And of course, we'll take a look at the legal frameworks of data protection and privacy, both the local one, that's the Nigerian one, and international with the focus on the Europe. Then we'll also look at the rights of data subjects. Of course, we'll definitely know who data subjects are. Then we'll look at their rights and their duties of That's rights of data subject and duties of data controllers / processors. Then, of course, we'll look at the current challenges in data protection. Then best practices for achieving global data privacy compliance. Take a look at that. Then why lawyers must understand both local and global standards. So as Nigerian lawyers, is it just is it sufficient for you to just be solely equipped with your local laws? Do you not need to expand your horizon, expand your knowledge by also trying to study other jurisdictions, laws on privacy and compliance? So we'll take a look at that. Then, of course, we'll look at the Freedom of Information Act. This is actually an act, as you already know, that enables you or that gives you the right to request a certain information from an institution, right? Which institution is unless it's that information is excused. We'll look at that. The institution is supposed to oblige you with that information. So what now happens wherein you ask for that information and this institution is saying that that information you're asking falls under the purview of data privacy? What now happens? Which one supersedes? Are you getting the point? So we'll look at that. Hope you all can still hear me.
Yes, sir.
Yes, sir, we can.
So I'm just talking to myself. So if at any point you cannot hear me, just let me know, please. Then we'll look at the role of technology in data collection, storage, and usage. We'll look at the legal implications of it. Then we'll look at the legal implications of technology and data connection. Then, of course, we'll look at opportunities for lawyers in data privacy and tech law generally. What opportunities are there for lawyers? Both law students who, of course, can aspire to transition in that area, and for even practicing lawyers who have that interest or that zeal to transition into that area. What opportunities are there for them? We'll look at that too. Then, of course, if you have the aspiration or you have the goal of transitioning into that area, there are some certain essential and important skills that you must build. You must equip yourself with to be able to possibly stand out and to be competent in that area. So we'll take a look at those. We'll take a look at those areas again, and of course, we'll look at just one or two case studies of organizations that have violated privacy laws, and of course, they were sanctioned. So we'll take a look at I think both local and international organization. So can you just give an OK emoji that you can hear me so we can proceed properly now? Okay, thank you very much. So as you can see from the slide, in the modern world of today, technology and data have become powerful drivers of transformation rather, across nearly every industry, including the legal profession rather. So what this paragraph or this thing I just read out is trying to say is that data, which we are going to see very soon, what we mean by, when we say data, what we mean by data, the elements or the things that qualify that come under that purview, we'll see shortly, that every organization, of course, the legal profession is not devoid of it. Every profession increasingly, knowing or increasingly seeing the essence of data, as it helps in making sure that whatever decision is coming out from the organization, is a well thought after, is a well conceived decision that would eventually, bring to fore the goal of that organization. So that's what this one is saying. In the legal profession, of course, technology is no longer just a support tool. It is an integral part of legal research, case management, evidence analysis, and client notification. By the way, maybe by the end of the lecture, if you guys are interested, I could push across this slide. So you just let me know if you're interested. I will put it on your platform. So tools such as legal research database, e-discovery software, case management system, and even AI-powered contract review platforms are revolutionizing how lawyers access information and deliver services. This technology improves efficiency, reduce cost, and enable fast decision making. Like I said, most organizations now, they are all now knowing, or they are now actually seeing the whole essence of data. That having a well thought after data, a well furnished data would help the organization in ensuring that the goal of that organization is met, and ensuring that whatever the target is for that organization, be it a law firm, be it a business organization, that eventually that goal or aspiration is achieved. It said, meanwhile, data has become a critical aspect in legal practice. Law firms and courts are increasingly relying on data analytics to uncover patterns, predict case outcomes, and support legal arguments. Data is also central to issues like cybersecurity, data privacy, compliance, and digital forensics, all of which are becoming key practice areas in modern law. However, the integration of technology and data into legal practice also raises a regulatory and privacy concerns. So, since we have to an extent now known the essence of, or as we're going to see in the course of the lecture, the essence of data, it also raises privacy concerns, it also raises some issues, some legal issues, which now mandated or which have brought about some regulations that have been put in place by different jurisdictions, including Nigeria, to regulate how data are being shared and how data is being used, so that it's not data will not be subject to misuse by the organization or by any of the data controllers or processors. The legal professionals must therefore be able to navigate through evolving laws on data protection and digital evidence while uploading core values like confidentiality, due process, and justice. So as legal practitioners, you would have known before now that the rule of confidentiality is one rule that is very key in legal profession, that whatever your client has told you in confidence, you are supposed to be with you, all right? So no account should you reveal it to a third party unless the consent of that your client is first sought and obtained. Are you getting it? So that's just what this part is trying to talk about. So in this dynamic environment, it's essential for legal professionals to not only understand the tools at their disposal, but also the implication of using them. So having spoken to the extent that there are some tools that, of course, incorporate data in their system to bring about decisions, to bring about solutions, that as lawyers, it's not just enough. It's not just enough for you to know that, okay, these tools are available, that you can use them. Like for instance, in my law firm here, we make use of the law pavilion electronic law report, if I'm not mistaken, to search up cases. We have had instances where we just needed to prepare one or two processes very urgently, that we will not really have that period of time to go through the normal physical NWA route. I get it that we just have to just quickly type in the authority we're looking for and it pops up. Are you getting the point? So the technology and even data as it is has actually made everything easy. But then again, as lawyers, it's not just enough for us to know that those platforms exist or they're available. We should also know the implications of using them so that at least we would be able to properly guide it. So understanding the basics now. So when somebody tells you that somebody asks you, for instance, what is data? How would you explain to the person that data is, or what materials fall under the understanding, under the definition of data? You can see here that data refers to raw facts, figures, samples that can be processed and analyzed to extract useful information. Like I said, they can simply means to collect a particular data. Maybe, for instance, if an organization is trying to maybe it's a very big organization. I don't know if this my example will fly, but let's just give it a try. And the organization is trying to know the number of maybe female or male staff that come to work early, for instance. All right, they can as well just give a form out for each of the employees to fill out, and of course indicate the time within which they resume to work on daily basis, and of course their sex. By sex, I mean whether they are male or female, their gender, everything. So with the help of what the company will have gathered, and we're able to tell that, okay, this is actually the category of persons that come to work early, the ones that come to work late. I get the point. But then again, as we're going to see later, if such an organization has so collected those information, those facts, it should be used solely for that purpose for which the data have been collected. So no account now should not use it for any other purpose other than the one that has been designated. I get it. So we're going to see much of that later. So in computing, data is often stored in a structured or unstructured format, ready to be manipulated for specific purpose. And of course, it said that data is lifeblood of the modern digital age, driving innovation, decision making, and growth across industries. And it's actually predicted by 2025, the year we're in now, that the global data volume is expected to reach an astonishing 182 zettabytes, right? If I'm not mistaken. Then, of course, this now further reinforces the importance of data, as we have been saying. Then from legal practice to healthcare and finance to entertainment and education, data plays a vital role in shaping strategies, predicting trends, and solving complex problems. I think I've highlighted on this part before. Then in the context of law and technology, data refers to any information that is collected, stored, processed, or transmitted by digital or non-digital means. Then this now brings us to the categories of data. So what are the categories of data that we have? Okay, as you have seen already, there are basically two categories. We have the personal data and the sensitive personal data. We'll take a look at their varying meanings very soon. Then in privacy and data protection law, there's a critical distinction between personal data and sensitive data, as each category has different implications for how the data must be handled under regulations such as the Nigerian Data Protection Regulation 2019 and the General Data Protection Regulation, GDPR. This is one of Europe. So personal data is any information that relates to an identifiable person or a natural person that you can use to identify that person. For instance, as I've seen, is the person's full name, his address, his email address, his phone number, date of birth, for instance, all come under the purview of personal data. So if you are trying to know the number of staff you have, like the example I earlier cited, you can simply ask them to, each person should put down their names, the employees put down their names. So by that way, you'll be able to know the number of persons that you have as per employees in your organization. So full names, address, email address, phone number, date of birth, IP address, all come under sensitive personal data, sorry. Then, excuse me, then under most data protection laws, including Nigerian Data Protection Regulation 2019 and the Nigerian Data Protection Act, personal data must be processed lawfully, fairly, and transparently. Individuals have the right to know how the data is being used, and in many cases, they must give consent for its processing. So we'll see the issue of consent later in the lecture, that even while we have agreed to the extent that most organizations that are data collectors and processors have the right to collect your data, of course, they should do that, by obtaining your consent. They should first of all obtain your consent before collecting such data, or before you give out such data. Then we have a sensitive personal data. Sensitive personal data is any information that, if exposed, will lead to discrimination, harm, or other negative consequence for the individual whom it belongs. So any information at all that, if a third party gets wind of it, if a third party hears it or sees it, it will put in some form of harm or any discrimination at all in any sort. Such a data is classified under sensitive personal data. And of course, you agree with me that this kind of data would definitely have stricter security measures in protecting them. All right. These data include health data, for instance, as well as personal data revealing racial or ethnic origin, political opinions, religious or ideological convictions. And because of its sensitive nature, processing this data usually requires, like I said, explicit. You have to be very explicit. You have to first of all obtain. You are not excused from not obtaining the data subject consent. So you must first of all obtain its consent before processing such data, and must meet specific legal justifications such as necessity for employment, public health, or vital interest. So I think to this extent we have known what data is now. The categories of data that we have, like I said, personal data, sensitive data, and we have seen examples of each of them that come under both personal data and sensitive personal data. You might want to ask that as a legal professional, as a lawyer, or as an expert in this area, why does this identification, or why does this thing we have discussed so far, and how does it even concern me? Why do you even need to bother yourself knowing the differences, or knowing what personal data is, knowing what sensitive personal data is, and the implication of both of them? Okay, so you will see shortly that for law firm or any legal professional, understanding the difference between personal and sensitive data is crucial. This is because lawyers frequently handle both types, whether it's client medical history in a personal injury claim, for instance, wherein somebody has briefed you, a client has briefed you that he incurred maybe injury at maybe at his workplace, for instance, or any other place, for instance, that there's a need for you to go to court on behalf of the client. Of course, you'll be privileged to have his data, privileged to have his information. So, and you are expected in that instance, you're expected to keep it, confidential. You are not to reveal it to any other person. That's the reason why you are supposed to know the difference. You are supposed to equip yourself with the relevance of these categories of data that we have mentioned. That's the personal data and the sensitive personal data. All right. Then, for instance, both whether it is client medical history in a personal injury claim, like I said, or biometric data in an employment dispute, or financial records in divorce cases. So maybe any of you feels that maybe you want to go into or specialize in a divorce matters, divorce cases. Then of course you know that the information that your client has given you as per the divorce you are handling, they are also confidential information that you are supposed to keep secret. You're not supposed to reveal it to any third party, because doing so you'll be breaching the rules of professional conduct. Okay, then so mishandling such data can lead to legal liability, reputational damage, and breaches of the professional conduct rules. Like I said, if as a lawyer somebody has actually confided in you that this is actually the situation, and you now, due to your negligence or inadvertently, the information gets to the hands of a third party, then of course you know that in that instance now you to cause you reputational damage as well as legal liability. So the client in that instance can even sue you for being negligent in handling his information that he has given you in confidence. All right. So moreover, law firms are considered data controllers or processors under data protection laws, meaning they have specific duties, right? So law firms generally, by virtue of the laws that we have that regulate data privacy, law firms are categorized or are considered to be data controllers or processors, all right? And as a result of that, they have some duties that are incumbent on them, some duties that the law have made that they are to fulfill. Some of those duties include ensuring that the data is secure. So ensuring data security, maintaining client confidentiality. I think we have moved overflowed on that. Then complying with legal obligations regarding data storage, access, and retention. Right? Hope you all can hear me to this extent.
Yes, sir.
Okay, thank you very much. So
Yes, sir.
that brings us to, thank you. That brings us to data protection versus data privacy. Like I said at the initial, these are two concepts that more often than not that are used interchangeably. So some persons even confuse them to mean the same thing, right? That when you mention the data protection, so we think you are mentioning or you are referring to data privacy. When you mention data privacy, we think you are referring to the other one. But then they actually, they actually have two distinct meaning. So we'll look at the meanings quite shortly. So the terms, the data privacy and data security, like I said, are used interchangeably and seem to be the same, but actually they are not the same. In reality, they can have different meanings depending upon their actual process and use, but they are very closely interconnected and one complements the other during the entire process. Take it on.
Hello, everybody. Please, we can have a little bit network glitches, so give us a few minutes.
Hello, can you guys hear me?
Yes, sir.
Yes, sir.
Okay, please apologies for the little hiccups there. We're having network issues. It has not been rectified. So I was where was I now, Seth? I think I was trying to make, yes, I was trying to make the point that, yes, data protection versus data privacy. I was trying to make the point that they are both two distinct concepts, but they are more often than none, seen to be one and the same. That exactly they mean the same thing, but that's actually not that's not the reality. So but they are very closely interconnected, and one complements the other through the entire process. So let us now see how data privacy differs from data protection, right? So what does data privacy mean? So data privacy simply refers to the proper handling of data, which means how an organization or user determines whether or what data is to be shared with third parties, right? Data privacy is so important as it keeps data secret from other third parties, so we can safely, please, just hold on, let's share the slide with people. Just go down a bit. So because I was making the point that data privacy refers to the proper handling of data, which means how an organization or a user determines whether or what data is to be shared with third party. So as an organization, having received the personal data from individuals, right, you should be able to put some mechanism in place to determine how that same data should be shared with any third party. Like I said, you should always, or as an organization, it's expected that you should only share it to a third party, haven't gotten the consent of that data subject. So you don't collect, though they are not without exceptions, but generally you don't collect data from a data subject and then you keep on sharing it to whoever you feel like sharing it to, without first having the consent or obtaining the consent of the person who gave you the data, who's the data subject. All right. So then we made mention that that the right of privacy is recognized under Section 37 of the 1995 Constitution of Nigeria and under international instruments such as Article 12 of Universal Declaration of Human Rights. So this right of the privacy of individuals, they are rights that have actually been enshrined in law, enshrined in the 1999 Constitution. So on no account now should an organization now breach that right to privacy. So wherein a person known as a data subject has given you his or her data as an organization, you are not supposed to breach it. By breach, you are not supposed to give it to a third party without first seeking the consent of that person who has so given you his or her data. But by so doing, you will have breached his or her right to personal, right to privacy, rather, as provided under Section 37 of the 1999 Constitution. Okay, then what then is data protection? Haven't known that data privacy.
Jeremiah, we will attend to your questions at the end of the class. So I forgot to tell you guys, if there is any question emanating from anyone, please drop your questions in the Q&A section. It will be attended to accordingly. Thank you.
All right, so thank you, Jeremiah, right? So just put down your question and at the appropriate time, definitely attend to the question. So,
thank you, sir.
Okay. So data privacy, like we said, refers to the proper handling of data, all right? Then data protection, on the other hand, refers to the process of keeping important data safe, right? So in simple terms, it refers to protecting data against unauthorized access, which leads to maybe to no corruption, no compromise, no loss, and no security issues of data. So wherein the other part of the data privacy is mainly concerned, with ensuring that the data subjects have given you, that those data are safe, you can as well see data protection as the means of keeping those data that have been so given safe from unauthorized access. I don't know if that distinction is actually clear, though we're going to look at some of the distinctions as we progress. Let's go down. Now, as you can see, differences between data privacy and data protection. A point again to note there that they are sometimes used interchangeably, but they, however, mean different things, as I've earlier highlighted. So data privacy, like there are differences now. While data privacy refers to maintaining secrecy or keeping control of access to particular data, data protection, on the other hand, is the process of protecting data from external risks, right? So that it does not really get to the hands of a third party who will now use such data that has been given for a purpose other than the designated purpose, right? Then data privacy is all about authorized access, like I said, meaning it defines who has authorized access to data. While data protection, on the other hand, is all about unauthorized access, meaning it prevents people from accessing people's information without their consent. So those are the mechanisms that have been put in place to ensure that the data that have been given by individuals are not accessed unlawfully or are not accessed by third party without the consent of the data subject, right? The data privacy is a legal process / situation which helps in establishing standards and norms about accessibility, while data protection is the technical control system which keeps data protected from technical issues. So while data privacy, again, as highlighted, these mainly with situations or processes, in order to help establish that there are some standards and norms that have been provided such that the data subject will know their rights, their duties, their responsibilities, as well as the data controllers. Data protection, on the other hand, deals more with the technical aspect of it, of the system. It deals with technical aspect of ensuring that those data that have been so given are not shared to a third party or are not accessed by a third party without the consent of the data subject. Then again, data privacy, while data privacy is regulation, or these principally with regulations or policies, data protection deals majorly with the procedures and mechanisms. All right. So data privacy is a legal and ethical concept focused on individual rights, while data protection is the technical and operational concept focused on implementing securities. So those are just the key differences that exist in the two concepts. So like I said, while data privacy deals majorly with the legal aspect of it, ensuring that, okay, as a data subject, you have the right. As a data controller, you have the duty that you owe to the data subject. Then the data protection, on the other hand, now deals with ways, mechanisms, systems that are put in place to ensure that there won't be any breach at all of data privacy. I don't know if that point is clear to that extent. Then again, they say, while data privacy teams are made of experts with lawmaking policies such as lawyers, data protection teams are made of experts from technical background, security background, who put in, like I said, system, put in checks, put in security measures to ensure that the data that has been given are not easily accessed by unauthorized persons, are not easily accessed by third party, right? Then we'll now move on to the concept of data privacy best practices, right? So what are the best practices that there is in data privacy? So we are told now that we should ensure that we understand how our current laws define personal information. So just in case you want to take up an action, on behalf of your client, you'll be able to familiarize yourself, or should be able to have a proper understanding of the laws that define personal information, the current laws that define personal information, to be able to know if the action your client is seeking for is actually even is actionable or is something that can be achieved in court. And of course, we should ensure that we use adequate consent management when collecting data. I think this is more directly to data controllers and processors. Like I said, which law firms are part of them now. That when you are collecting somebody's data, collecting people's data, ensure that there is a consent that is obtained from the onset before such the data is collected. Then of course you are only allowed to save only the most important information. So now this one is that. So wherein you are in a platform, where you have been asked to put one or two things as per information. So it's always advisable right? That you should put on those information that you know that are actually necessary, you know, to that particular task you are trying to achieve. Like in most platforms, online platforms, like maybe online apps also, I didn't know for a fact that there are usually options for mandatory things you have to fill and optional things you have to fill. So you should ensure that you only save the information, if you are saving information on that app, on that platform, ensure that it's only the information that are important that are saved there. And of course, we should take strict measures to prevent human mistakes. Okay, just a quick one to see that we are all following. How many of you take time to read the terms and conditions of most apps that you are subscribed to before clicking on accept? If you want to speak, you can just I want your honest answer. If you know you usually take time to go through the lengthy terms and conditions before clicking accept, right? You tell me, then of course you tell me reasons why you feel you
Afternoon, sir. Can I go ahead and talk? Afternoon, sir.
is necessary. And if you do not actually do that, if you don't accept, is that Alim? Is that Alim? Okay, let's have Ali Muhammad.
No, I'm actually. Hello?
I can hear you. Is that Ali Muhammad?
No, I'm
Okay.
actually.
All right. So I can hear you.
Sometimes, if I'm not already trying to like sign up for the thing, I sometimes read the terms and conditions, not to so that
Alim, I can barely hear you. Your environment is actually noisy. I cannot hear you well.
Yeah, I'll say. Hello. Hello.
Yeah. Yes, is
Hello.
noise is coming from your background. You try and speak. Let's see this time around.
Sometimes when I'm not always to sign up for the app or something, I sometimes read the terms and conditions. Just not to so that I will like sign up for something that will later regret or something that will later be used against me. But sometimes in the terms and conditions, it like contain some terms like maybe your data might be used for like an ad later on in the future or something like that. And for a person that doesn't want his data to like be shared to like the public or used for something like that, such person I just need to like such person I just need to such person I need to like disagree to that to the terms that will like complicate with that in the future.
Alim, I'm assuming I could not actually hear you properly, but I'm assuming you said that you usually go through the terms and conditions, so you don't go and subscribe for something that would that will not have a consequence later.
Yes.
Okay. Thanks for that response. Can we have Adeze and Nikolum? Sorry if I'm not pronouncing your name well.
No problem. Good afternoon. Okay, I don't know. Can you guys hear me? I don't know. This thing is not. Can you hear me, sir?
Yes, I can. I can hear you from my end here.
I'll be honest with myself. I don't usually go through terms and conditions of those ones that are very, very long. But just anyone I see that is short and something that has to do with bank or school something. Some of them will be like, from time to time, we'll be having access to your personal information. And some of them, there was even this app I wanted to download, and they'll be like, we'll be having access to your bank details, this, and this. But I don't usually use to, like, I don't usually used to use my personal details that's related to my, anything that has to do with my bank, because that one is money. So anything that has to do with them having access to my social bank details or all these things, I don't usually used to accept those kinds of things.
Adeze, thank you very much for that honest response. Although it's not just we are not alone in this. Most persons usually don't take their time to go through terms and conditions, especially when he has no information pertaining to the banks, as you have rightly posited. Right? Thank you. Then let's have one more person. Chinoye Munachi.
Good afternoon, sir. Good afternoon, everyone. Sir, can you hear me?
Yes, I can. Thank you.
Okay. Sometimes, like majority of the time, I go through the terms and condition. But like, for example, if it's a new app, or if it's like Aveze said, if it's something relating to, say, a bank. But then most times I really need the app, or I really need the application. So I would just say click on agreed, because I need it more than the whole terms and conditions. So that's my own take.
All right, thank you very much for that response again. To be very honest with you, I have to be very frank and candid here. I'm equally guilty sometimes, if not most times. I'm equally guilty of this issue that I just maybe as a result of you're in a hurry, or you just want the thing done, you just click on without having to go through the lengthy terms and conditions that have been put up there. But then again, to be very honest, it's actually very good, right, to go through those terms and conditions, so that at least you can be aware of any hidden clauses that possibly are not in your favor as a user, and of course the privacy issues, and so that you don't eventually incur any legal risk at the end of the day, right? So that's just by the way. So thank you once again for your responses. So the next, as you can see from our slide, the next topic of discourse now is the legal framework of data protection and privacy. Legal framework. What are the laws that have been put in place, right, specifically for data privacy? Like I earlier highlighted from the beginning of the lecture, that we'll be looking at both the local one, that's Nigeria, and of course the international one, with a focus on the Europe continent, which is the GDPR. So on the pertaining to Nigeria, we have principally two laws that we'll be discussing. One of which is the Nigerian Data Protection Regulation of the 2019, right? That it was introduced by the National Information Technology Development Agency, NITDA, and it basically requires organizations to obtain consent, right? Publish privacy policies and secure personal data. So like we have been emphasizing on this issue of the consent, we have overflowed itself. So here is also reinforcing the fact that you should obtain consent from the data subject, and of course you should do well to publish your privacy policies. Let the user actually know what is obtainable as per your privacy policies. Let them know that, okay, they subscribe to this. This is what this is data that possibly might be shared with the public, data that will possibly be shared by a third party, and the ones that are not that will not be shared at all in any event, right? So the organizations are expected, as per responsibility, they're expected to publish their privacy policies, right? I think we skipped one vital thing that I was going to point you guys, yes, on the definition of some keywords. So as we're discussing further, we'll be following. So by data controller, what we simply means is an entity or an individual responsible for determining the purpose and method of processing data. So any individual, any establishment, any entity that has that mandate of determining the essence and of course the method of processing personal data falls under data controller. And of course, data processor is the entity, again, or an individual that handles the processing of personal data on behalf of data controller or the direction of the data controller. So the data controller is just like their model, should I call it mother company or the mother head now, right? He's the one who's actually in charge of determining the purpose of using that particular data. Then, of course, the data processor is not the one who now handles it on behalf of the data controller. The data subject, on the other hand, is a person whose personal information is being collected, processed, or stored by an organization or entity. So just you and I, we fall under the category of data subject. So we can proceed now. I just wanted to highlight that point so that as we are going, we should know what we mean by, when we mention data controller, data processor, data subject, we should know what we mean by those concepts. Then, like I was saying, that one of the regulations, one of the laws regulating data privacy in Nigeria is Nigerian Data Protection Regulation of 2019 that was introduced by NITDA, and it has been observed that the personally identifiable information of Nigerian citizens is often processed by unauthorized individuals without their consent, raising serious concerns about data misuse and violation of privacy rights. This unlawful processing exposes individuals to risks, including loss of rights, reputational harm, and emotional distress. In response, the National Information Technology Development Agency established the Nigerian Data Protection Regulation in January 2019. So they're just trying to give you a background of how this Nigerian Data Protection Regulation 2019 came about, what actually brought about it, what actually prompted, the establishment of it or the enactment of it. It was because they observed over time that the personal data of individuals were now subject to misuse. There were a lot of violations of privacy rights, which now necessitated or brought about the establishment of the Nigerian Data Protection Regulation of 2019. Of course, the point is highlighted that under the authority of Section 6 of the NIDA Act 2007 and Section 37 of the 1999 Constitution is like the sections or the section of law that gives backing to the establishment of the said Nigerian Data Protection Regulation of 2019. Then note, NDPR serves as Nigerian primary legal framework for regulating data protection and ensuring that personal data is processed lawfully, fairly, and securely. The NDPR outlines key principles that must guide data processing, including consent, purpose, limitation, data accuracy, and secure storage. So the NDPR, now having been established now, have now come up to provide some principles that should guide the data processing, which includes consent. I think by now you should be aware or be abreast of what consent is in this regard. I've highlighted on that. Then purpose limitation. So wherein you have collected the data of data subject for a specific purpose. So you shouldn't use it for another purpose, because the purpose the data subject has consented to was the initial purpose you had an agreement with, or you told him that you actually consented to. So having gotten that data, now you are not expected, as per your responsibility, you are not expected to now use that same data for a different purpose other than the purpose that you had earlier indicated, or you had earlier told or informed the data subject. So that's what we mean by purpose limitation. Then data accuracy, of course, having given you his or her data, you should be able to put it down accurately, just in the same way and manner he has given you. So no account, should somebody tell you that he's male, then your record they are putting female, right? It's actually it might look very consequential and trivial, but then some persons might not be so happy with it that they are full-grown men, they are male, why are they having a female on their profile, right? So you should ensure as an organization that when you collect data, that the data you have so collected should be putting them down, should be accurate, just in the same way and manner the data subject has given you. Then and the data storage will ensure that it is stored in such a way that, like I said, will not be accessible by unauthorized persons at the dispense of the data subjects. So it emphasizes that data must be collected for specific, like I said, specific lawful purpose with data subject consent, and must be kept accurate, confidential, and stored only for as long as necessary. It also requires data controllers and processors to implement adequate security measures against foreseeable risks such as cyber attacks, unauthorized access, or natural damage. Moreover, data subjects are granted essential rights such as the right to access, correction, deletion, or subject to the processing of their data, as well as the right to data portability and to be informed about how their data is used. So when you have given this one, just trying to bring to fore the fact that if you have given your data, if you at the time you give your data, you were single, you are still a single man, a single woman, and luckily for you, you have found the Mr. Right, the Mrs. Right, you are now married. So you have the right to approach any of the data and say, okay, please, I want to have my data modified or altered as per your status now that you are now married. All right. So that's what this one is talking about. The Nigeria Data Protection Act of 2023. Then the point is highlighted that on June 13, 2023, the Nigeria Data Protection Act 2023 was enacted to provide a more extensive regulatory framework for the protection of personal data in Nigeria. The act established Nigeria Data Protection Commission
Sorry, sir, we can't hear you, sir.
I can hear you. Sir, we can't hear you.
Sir, I don't know. I can't hear you.
Right, in line with GDPR, right? So the point we are trying to make here is that having had the Nigerian Data Protection Regulation of 2019, it was now discovered that it was maybe it was not fully meeting up to the purpose, so it was not fully, I don't want to use the word it was not fully functional, but it was not really treating the issues that were coming up, right? So that now gave birth to the Nigerian Data Protection Act 2023, and that act now allows for the establishment of a commission as in Nigeria. Can you guys hear me now?
Yes, sir.
Can you hear me?
Yes,
So
sir.
at what point
Yes,
now
sir.
did you
Yes,
guys
Yes, sir, we can hear you.
at what point did you stop hearing me so I would know where to continue from?
I think that part when after you finish explaining the Nigerian data protection regulation, that was the last data law I heard you explained.
Okay. Thank you very much. So I was making the point that in spite of in spite of the Nigerian Data Protection Regulation 2019 that was put in force, it was now seen that it was not really meeting up to expectations, or it was not really fully covering for what it was supposed to cover for as per data privacy, right? So it was on that backdrop now that the Nigerian Data Protection Act of 2023 was now established in 2023. And the act now enables or makes it possible for there to be Nigerian Data Protection Commission, such that when you have any issues as per data privacy, even before resorting to court, or even before going to court to enforce your right, you can simply just write maybe a demand letter or write any complaint at all to the Nigerian Data Protection Commission, and possibly they could have it resolved. And when it is resolved, there will be no need for you to visit the court to enforce any right again. So then the point was also made that the act established that Nigerian Data Protection Commission and introduced stronger enforcement and sanctions, and also recognized data subject rights in line with the GDPR, such as data controller, data processors is required to process personal data in a fair, lawful, and transparent manner. Personal data should only be collected for specified, explicit, and legitimate purpose, and not used for other incompatible purposes. Data controller, data processors shall ensure that personal data is adequate, relevant, and limited to the minimum necessary for the purpose. Personal data should not be obtained for a period longer than is necessary, and the personal data must be collected, in an accurate, complete, and up-to-date format. So this is just some of the should I call it amendment, or some of the modifications that was now put in place at the introduction of the Nigerian Data Protection Act of 2023. Then again, a point is highlighted that for lawyers, these principles reinforce the ethical duty of confidentiality, which provides under the rules of professional conduct that whatever your client has told you a confidence should not be disclosed to a third party without first obtaining the consent of your client who has so given you that information. So I would like to just throw one or two questions here, just to test how far we have possibly followed and possibly read. So, can you all hear me?
Yes, sir.
Okay.
Yes, sir.
So I haven't understood the fact that whatever your client tells you in the confidence, you're not supposed to disclose it to a third party. I want to just post just a little scenario now to test our understanding. So if you have a client, right? If you have a client who comes and tells you as a lawyer that, okay, Mrs. Veronica, or Barrister Veronica rather, tomorrow I'll be going to rob a particular bank, right? To rob a particular bank, and I'm anticipating that I could be caught. So should I be caught? I will need a legal representation from you. So you represent me as my lawyer, as my lawful attorney in court. Should the police catch me, you would represent me. So as a lawyer in this scenario now, what do you think you would do? Or how would you approach what he has just told you now? So if you want to speak, just raise up your hand so I can just call out your names. I can see Judith Ogochukwu.
Yes, sir. It's
Okay.
Ogochukwu, sir.
Okay. Did you hear my little scenario question?
Yeah, I heard you, sir.
Okay, so what would you do in that instance?
Okay, what I will do is that I'll have to tell him that I am not going to represent him, or rather, I will go to police station and report that there will be robbery in so place that he mentioned, in so bank that he mentioned, because it's not good for you as a lawyer to represent somebody that is going to cause harm, like stealing, something like that. Is illegal. So
Even as he has told you in confidence as his lawyer.
Yes, you don't have to represent him because it's illegal. You have to stop your work as a lawyer. You have to stop illegal activities. So if you're going to represent somebody knowing fully well that is going to steal, so why then are you a lawyer? Something like that. You don't have to represent him. The only thing you have to do is either you don't take the brief, just tell him that you're not going to represent him, or you go and report him in the police station. You may not tell him that you're going to report him or no, because your life is also at stake, because this person may be dangerous. So what you do is just to go to the police station and tell them that a crime will happen so at so bank by this time ahead, something like that. I think that's what I would do.
All right, thank you very much, Judith Ogochukwu. Thank you for your well-considered answer. So let's have God's favor, Afo.
Okay. So can you hear me, sir?
I can hear you.
Okay. So to that, based on the scenario you have given, I would say I would report the case to the police, because even the particular section of the RPC that provides for, duty of confidentiality of a lawyer to his client also provides for some exceptions. And commission of crime is one, I think 19.3. So if a client discloses his intention to commit crime, he has not committed it, but discloses the intention to commit it, you can, as a lawyer, you have the duty, or you are not necessarily obliged to keep that confidential, basically.
Okay, thank you very much, God's favor, Afo. I think from the responses I've gotten, you guys are actually there are so many gurus in the house, right? So that's just it basically. So if you go through this rule 19 of the RPC, in as much as the rule of confidentiality is there, right, it does not pertain to the commission of a crime, and there's a distinction where a client comes and meets you that he wants to go and commit crime. It is obligatory on you as per even the criminal code, because when you go through the criminal code, what an offense is there, how an offense is defined there is an act or an omission. An act meaning someone who is actually committing, who has committed it. An omission, somebody who is who had the knowledge that a crime was going to be committed or has been committed and failed to do the needful by reporting to the necessary security agencies. So you have equally committed an offense, right? So if your client is coming to tell you that tomorrow I will be going to rob a particular bank, so should I be caught? Please represent me. It now becomes mandatory to go and report, because if you fail to do so, you have now committed an offense by virtue of the fact that an offense is an act or omission, right? But wherein he has okay, let me ask this question now. Then if he has now told you, so I would want God's favor to answer this now. It seems you have gone through the RPC now. Wherein he now told you, now the scenario is now different now, that he has told you that he has committed a crime already, but he just needs a legal representation. So would your answer still be the same, or you would have a change of mind? God's favor, Afo, if I'm not mistaken.
All right, sir. So to that, I would say my answer would not be the same, because the RPC, based on what it stipulates, is if he discloses his intention to commit a crime, that is, true, by the way it was phrased, he shows an intention to commit it in the future. So if he comes to disclose a crime already committed, right, it's not left to me to decide whether I want to, based on my own personal interest. Of course, there's a carte blanche rule, but based on my own personal interest, whether I'm going to be able to represent him in that case, or I'll just step back. But to report that would not be entirely appropriate. But if it is the case that he wants to, then that would be mandatory on me to report it.
Okay, thank you very much again, Afo. That's actually my own, that would be my own verdict too, that if for any reason, as long as the act the person has already occurred before he comes to meet you, if for any reason, maybe out of any of your, should I call it religious belief or any sentiment at all, that you feel you cannot go on with the case or you cannot handle the case at all, then you can simply just turn him down. But then again, whatever he's giving you in that instance now, whatever he's giving you in confidence, because the act in question has already been committed, right? So you can see that it's actually different from the earlier scenario I painted, which had to do with him telling you that he would be going to commit a crime. Not that he has committed, that he was going to commit a crime. So now it becomes obligation on you to inform any of the security agencies that, okay, the XYZ would be robbing the bank tomorrow, right? So that's just a little distinction I just want to give this. I'm just trying to make the point that the rule of confidentiality has provided under Rule 19 is not absolute, right? There are actually exceptions. There are exceptions that there are exceptions that would permit you as a lawyer, to reveal the information that your client supposedly has given you, the information has given you in confidence. And one of them, one of those exceptions, is just the one we've just seen in the form of a scenario question. So let's quickly move ahead. Okay, so the next topic on our discourse is scope and applicability of Nigerian Data Protection Act. So they said the act generally applies to the processing of personal data, whether it is conducted by automated means or not. The section 2 of that same act, 2 sub 2 of the Nigerian Data Protection Act, identifies 3 exclusive instances where the act will be applicable. First, the act applies to data controller or data processor who is domiciled in, resident in, or operating in Nigeria. Then secondly, the act applies if the data processing takes place in Nigeria. And thirdly, the act applies to a data controller or data processor who does not reside or operate in Nigeria, but processes the personal data of a data subject in Nigeria. So these are the 3 instances wherein the Data Protection Act has been enacted in the year 2023, the coming for. That the act does not apply where personal data is processed for the purpose of crime investigation, public health emergencies, national security, or the publication of matters in the public interest of journalism. So this is just like an exception, as we all know before now that to every general rule, there are usually exceptions. There's no rule that is actually absolute that does not have any exception at all. No, most rules actually are exempted, or they have exceptions or exceptional cases wherein the general rule will not apply. And this one is saying that when it has to do with a crime investigation, who is muted? Can you please mute yourself so that we don't? So one of the exceptions is crime investigation, public health emergencies, national security. So if any of these aforementioned cases occur, then the general principle of data protection will actually not apply. So it therefore now means that the data controller is now allowed by law now to share the data so collected to a third party, maybe a government organization or a security agency in the case of crime investigation, without first seeking the consent of the data subject, right? And of course, the point is also highlighted that there's a requirement of consent before personal data is collected or processed. This is something we have really overflogged. The data controller or data processor must obtain the informed consent of the data subject. However, before the consent is granted, the data subject must be informed of their right to withdraw consent, right? So before obtaining the consent to collect such data, you should also do well as a data controller or processor to inform the data subject of their right to withdraw consent from the consent they have given already. So the act provides that the withdrawal of consent does not invalidate previous processing. So wherein the data subject has given his consent, right, and further now withdraws his consent. So whatever data that has been processed before the withdrawal of that subsequent consent, will not be affected. Then the data controller or data processor is tasked with supplying the following information to the data subject: the identity or residence of the data controller, lawful basis and purpose of processing, data subject's rights, retention period for the personal data, right to lodge complaint, and the existence of automated decision making. So the data controller has a responsibility, he owes to the data subject to first of all tell him his identity, what's the name of your organization, where is your office located, the data they are collecting is for what purpose, right? And for what period of time, for how long would you retain such data? If the specific purpose or the designated purpose for collecting that data is met, would you still retain the data of that subject, data subject, so that the information that responsibility that as data controller, data processor, you are supposed to provide we're supposed to oblige the data subject with. Then again, the point is noted that the data subject may give consent in writing, orally, or through electronic means, right? So the consent that we have been emphasizing on now, how do we now give that consent?
I feel
It's
like
highlighted and make.
I'm beginning to have like interest in the law now because like I've realized how broad it is. It's not that broad. Yeah.
Hello, who was? I think we just got a little distraction there. So I was making the point that data subject may give consent in writing, orally, or through electronic means. So the consent I'll be talking about now, they actually may give it in three ways. Principally, they may give it in writing, orally, or through electronic means. So what now happens to persons who generally, in law that they don't have capacity to give consent, such that whatever consent that they have given is invalid, does not amount to anything. Persons like children, or persons lacking the capacity to consent, like a lunatic, what now happens? If they give you, if they so give that consent, would it be valid? Or was now the alternative means of giving consent, wherein it is a child that is involved or a lunatic that is involved? So as can be seen here, that you can actually get the consent from their guardians, that in these cases, the act directs the data controller to obtain consent from their parents or guardians instead. So wherein the data subject is a child, or is somebody who is not really of somebody of unsound mind, then you can collect such consent from his guardian or parents, as the case may be. The sanctions and penalties, right? Just like to every law, there are usually sanctions that follow. That's one of the elements or requirements of a good law. A good law must definitely have sanctions put in place or penalties, such that when somebody violates or goes against what has been provided, then the sanction will come into play. So the Nigerian Data Protection Act is one of them. So the Act introduced strict sanctions and penalties to deter data controllers and data processors. Under the Act, the Commission can issue compliance and other orders with consent, with content such as providing warning, requiring compliance with the Act, or commanding persons to cease and desist from engaging in specific conduct. So this one now, like I said, remember what I said earlier, that the Act that we have now, the one of 2023, established the Commission. So the Commission has the mandate, has the power to issue any data controller or data processor warning. Having received a complaint that is violating data privacy, can issue the organization a warning to desist from such misuse of data. And of course, wherein you agree that the data subject, you cannot, nobody can stop you from approaching the court. So nobody can ask the decision of the court. So you can equally go to court. You have the right, to go to court to seek for damages from the data controllers, data processors who have misused the data you have given them. The international framework, so we have to just be quick with this, because I later got to know that we're having another OVIP session today, right? So we just have to be very, very fast, as fast as we can. What that we have is General Data Protection Regulation, of course, and understanding the GDPR overview. The General Data Protection is a robust data protection law that came into effect on May 25, 2018 in the European Union, and was designed to harmonize data privacy laws across Europe. So this is like a unified laws that they have that regulate data privacy in the whole of Europe, right? And the key principles of it are that is just akin to, or is same with the one of the data protection of Nigeria, that there must be lawfulness, there must be fairness, there must be transparency in the processing of data, right? And purpose limitation, that the data should be collected for a specific, explicit, and legitimate purpose. So you should not collect somebody's data for a particular purpose and you're not using it for some other purposes. And accuracy, the personal data must be accurate and kept up to date. There's storage limitation. Data must be stored only as long as necessary for the purpose for which it was collected. Then integrity and confidentiality, data must be processed to ensure its protection against unauthorized or unlawful processing and against accidental loss, destruction, of damages These are some of the key principles of the GDPR. Like I said, this is actually applicable to the whole of Europe. It's more like a unified law that they have here as per privacy, for data privacy. The penalties for non-compliance. It's just like in the case of data protection in Nigeria, wherein if you fail to comply with the principles, you might be sanctioned, you might be made to pay fines. That of the GDPR also has its own penalties for non-compliance, which is like fines up to 20 million euros or 4% of the total worldwide annual turnover of that company concerned. So any company who is in violation of this data privacy, can either, depending on the nature of it, can either be made to pay 20 million euros or 4% of its annual turnover. The right of data subject and use of data controllers. So like I said, I would push the slide across so you can go through it. You have to just think, well, we really spend time explaining some concepts. So as already noted above, in the context of data protection and privacy regulation, a data subject is the person whose personal information is being collected, processed, or stored by an organization or entity. This can include customers, employees, website users, or any individuals whose personal data is being handled by an organization. So their rights include right of access. So as a data subject, you have the right to access your data, right? You have the right to correct your data, like I said. If you are at the point of giving your data, you're not married, so you have the right to, to correct your data to reflect your current position or your status. And of course, we have the right of data portability. So this right actually simply means that that the what's it called now? Data should be given if you request for such data, you should be given in a very readable format without undue delay. So if you approach the organization that given data to and you want any information, right, you should be given in a very readable format without undue delay. Then of course, the duties of data controllers to processors, we have the duty of consent. So they must obtain consent, as we have earlier noted, they must obtain consent from data subject before collecting their data, and they must ensure that the data so collected is kept saved without access by unauthorized persons. And wherein a breach has occurred, you owe it as a duty to the data subject to inform them that there's actually a breach, right, of the data, so at least they would be informed of the developments. Then we have the current challenges in data protection. So we just highlight some of the current challenges, one of which is the cybersecurity risks, right? So which can possibly lead to financial loss, business disruption, or reputational harm, right? There are hackers everywhere trying to hack into most organizations' platform. Then we have cross-border data transfers, for instance, wherein the data in question involves two countries, which law will now come into play. Now, maybe you are transferring data of, maybe the company is actually resident in Nigeria or resident in America, for instance, and you are collecting data of Nigerians, data subject are Nigerians. So what law now will come into play now, right? So the points are highlighted that cross-border data transfer involves moving personal information from one country's legal jurisdiction to that of another country. Data can be effortlessly shared and stored across borders, but different privacy laws in each country create challenges for organizations trying to stay compliant with user information when user information is spread across multiple jurisdictions. So as a lawyer who is interested in possibly going into this area, you should as well be abreast of most both local laws as well as international laws regulating data privacy, right? Then of course we have the best practices for achieving global data privacy. What are the best practices that you should imbibe as a professional, as a lawyer? You should ensure you conduct regular data audits, you implement privacy design, you educate employees on data privacy. So if you happen to be a DPO, data protection officer in an organization, you ensure you educate those employees in that organization of the do's and don'ts of data privacy, so they will be updated. Then utilize privacy compliance softwares. So while lawyers must understand both local and global standards, so lawyers must understand both local and global standards to ensure legal compliance for clients in international business and cross-border transactions. So as a lawyer, your jurisdiction perhaps may not be limited to the local jurisdiction. So where you now have a client who stays overseas and wants you to do a matter for him involving data privacy, right? So you wouldn't tell him that you are not abreast or you are not knowledgeable, you don't have experience or you don't have knowledge of their privacy laws. You should do well to have this, even if it's a peripheral knowledge of their laws, combining with your own local knowledge. So that's why it's important that as a Nigerian lawyer, that we should understand both local and the global standards regulating data privacy. Then to the question, Freedom of Information Act versus the data privacy. So wherein, like we have highlighted now, that if you have given your data to an organization known as a data processor or data collector, as the case may be, that an unauthorized person is not allowed to access those information. Now we have, on the other hand, again, the Freedom of Information Act, which gives Nigerians or gives individuals the right to access some certain information from an organization. So when you are now trying to come under the purview of the Freedom of Information Act to request a particular information, and the organization is telling you that the information you are asking for or you are requesting from it falls under data privacy, and as such, they cannot oblige you, what will not happen, right? So the point is highlighted that okay, I think we took time to explain what we mean by Freedom of Information Act, the number of persons that it applies to, which is an applicant, public institution. Then look at the question: what happens when someone requests personal data? So FOI, that's Freedom of Information Act, Section 14. You go through the Section 14, they exempt personal information unless consent or overriding public interest justifies disclosure. So you can see that to an extent now, this data privacy, should I say, supersedes or is of more priority to the Freedom of Information Act, unless public interest justifies disclosure. So where you are coming under the Freedom of Information Act to request a personal information of somebody, right? So the institution is allowed to decline your request on the ground that the information you have so requested falls under the personal information of another person, and you should seek the person's consent before coming to request for such information, unless there is a public interest that justifies that disclosure. And in that instance now, then the consent will no longer be required. Then how to request for information under Freedom of Information Act and the NDPA. So for the Freedom of Information Act, you have to just be specific. You keep the proof of the decision you have, the request you have made to the organization, and of course, you are expected to wait for response. These 7 working days, you should get a response from the organization, and the response could either be negative or positive. So if it is negative, for instance, you can seek a judicial review for them to have what's it called now? The information you have sought from them. As you have declined, you can seek for review to have that their negative or their decline reviewed, possibly to a positive note. Then NDPA. So in requesting for information, that is NDPA, so you have to submit a data subject access request with ID proof, request access, correction, erasure, expect response within until delay. So if you are the one that have given information before, like I said, and now maybe your what's it called now, your status has changed, and you want to modify, you want to change the earlier information you have given, so you can just with your proof, your ID card, so you request for that information that either your name should be corrected or it should be erased totally. So should be erased totally, yeah. So we now have the enforcement and remedies. So when you have sought for the information, maybe they are not meeting up to expectation as per the data controllers, then you can do either of these two. So if a public institution refused, the applicant can apply to the court for review, and the court can order disclosure and have powers to hear matters summarily. So this is pertaining to Freedom of Information Act. So like I said, is an act that has been enacted to allow individuals access public information from public organizations. So if you have sought for that information and they are refusing to oblige that information, and you feel that information does not fall under the purview of the private data, or does not fall under the purview of anything as by exception, then you can now apply to court to have that their decline or their negative response, have it reviewed. Then for NDPA, for complaints, you have to go to the NDPC, that Nigerian Data Protection Commission, and the commission may issue compliance or enforcement orders, and of course, we impose a sanction as the case may be. We quickly look at the role of technology in data collection, storage, and usage. So we have already highlighted the essence of technology in today's world that is very central in how data is collected, stored. They make use of platforms, apps that allow for easy access, that allow for easy transfers of this information, right? So we look at the data collection technology as a gateway. So media technologies make it easy and often invisible for organizations to collect personal data. Like social media platforms, we have Facebook, Instagram, they collect data such as user profiles, posts, likes, location, and the likes. So the legal concern in this now was consent obtained. So was consent obtained in collecting those profiles, those user profiles, those data that have been collected by platforms like Facebook, Instagram, X, former Twitter. Was consent obtained? That's the legal consent that should concern you, as a lawyer, as per the GDPR or national privacy laws, right? Then we have the data storage. The technology has evolved. The point is highlighted that the storage of data has evolved significantly with the rise of cloud computing and distributed databases. So we have platforms like AWS, we have platforms like Google Cloud, right, that enables companies to save data, save information in the cloud without necessarily having to have a physical copy of it. So the legal concern that should bother you as a lawyer now is where is the data stored? So we also have the issue of a jurisdictional issue. Is it encrypted? Who has access to it? The data controllers compliant with cross-border transfer rules, wherein an organization maybe has a mother company in Nigeria and maybe a branch or another office at the US, and they are sharing data across the two countries, across the two jurisdictions. So what should concern you in this regard now is, where is the data stored? Is it stored in Nigeria for you to know that, okay, it's Nigerian court or Nigerian laws that should have jurisdiction, or is stored in the other country, maybe UK or US, as case may be? And the data controllers, are they complying with the cross-border data transfer rules, right? These are some of the legal concerns that would concern you under the head of data storage. Then the third one is the technology as an engine. So once collected and stored, data is analyzed and used for a wide range of purposes, some helpful, some potentially intrusive. Then legal concern here is the use transparent and fair? Have you collected that data now? Are they using it in a fair manner? Are they transparent in the usage of the data? Are users informed of how the data is being, what the data is being used for, or how it's being used? So have you collected that data now? The users that have given that data, are they really informed? Are they abreast of how their data is being used, what they are using their data for? These are the legal concerns that would come under the head of technology as an engine. Then, of course, we have a legal implication of technology in data collection. Like we said, consent and transparency. So the users are clearly informed about collection and use. So the user should be well informed and should be transparent in the process. So data minimization, our organization only collecting what is necessary. So wherein as an organization, what you need to process a particular information is maybe the person's name, his full name, his email address, and phone number. So why are you asking for the person's religion? Why are you asking for the person's political view or something like that? So you should only collect what is necessary, to help you achieve that the goal you have set out to achieve. Then we have the security obligations, proper safeguard in place to prevent breaches. So here, just saying that have you put in place, proper mechanisms, proper procedures to ensure that data that have been given are not leaked or are not hacked or seen by unauthorized organization or persons. So for lawyers, this means staying updated on the tech development, legal framework, and ethical standards around privacy and fairness. Then look at for opportunities for lawyers in data privacy and tech law. We have diverse opportunities for those who are interested in the area of law. We have data protection officer, DPO. So you might want to, in the future, become a data protection officer, where you will have understood the concept of data privacy, data protection, to be able to organize or advise your organization, on the need to stay compliant with the data protection regulations, right? Then you can as well be a fintech lawyer where you would be in charge of ensuring that maybe banks or any financial organization is staying compliant with laws that regulates it, such as maybe CBN policies, for instance. Then you can as well be a cybersecurity lawyer, which will now focus on the governance risks and compliance. Then, of course, you can be just a general compliance officer, wherein you'll be there to advise organizations on the laws that guide them. So if you are in a tech company or you are in a business environment, any environment at all, you just, as a lawyer, you just look for laws, regulations that guide that organization and ensure that your organization is staying compliant with those laws that have been so established. So if you are now interested in any of the aforementioned career paths, the essential skills you need to equip yourself with. And one, you have to be aware of aware of the technology world. Simply put, as technology is evolving, you have to stay updated of the new changes that have been made, new modifications, new rules that are coming in place to put in checks to the practices that are coming into play on a daily basis. You have to stay updated on it, so you at least will be abreast of all the information. Then drafting data sharing, equally important is the ability to draft and review data sharing agreements. So as a lawyer, ordinarily, you should ordinarily have the ability to draft documents. So as somebody who is now interested in data protection field, then you should have the ability to draft data sharing documents that will bind the data processor and the data subject. Then, of course, you should have the ability to advise generally on compliance, advise the organizations you are working with on compliance, the reasons why they should stay compliant with the laws and regulations guiding the organization, right? Because if they don't do so, there are usually fines that follow, not to mention the reputational damage that would cost if such unauthorized such data is accessed by an unauthorized person. So we now have some case studies. You can read it at your convenience. So we have highlighted for GDPR fines, we have highlighted one issue that happened. We have the Google, the British Airways. Just take time and read it. So it was actually a data privacy issue that occurred, and the company in question was fined, a very huge one. Then we have for Nigerian enforcement, we have another country, a company by name Electronic Settlement Limited, that was fined for data breach to the tune of 5 million naira. So this just goes to reinforce the fact that, when you breach data privacy laws or rules, there are usually sanctions that follow. So some of the sanctions, like I said, include the fines. They could also include the reputational damage. So I think that would be all for me in this section.
So we basically have we can only take just one question. Then the rest of you, we're going to send in the slide. The rest of you, if you have further question, you can follow up on his LinkedIn profile. You can drop your questions there. He will respond to them accordingly. Please, we're going to take just one question. Emmanuel. I can't hear you. Emmanuel, we gave you an opportunity to ask questions, but in the absence of that, please can we have Una Eza Uzo? You can just quickly ask your question.
Okay, good afternoon, everyone. My question, first of all, I want to thank the speaker for this insightful topic and lecture he has taught us so far. So my question is, there is something I saw on Facebook about some organizations whereby if you upon your application, they will require a request for your health status and to be specific HIV status for HIV patients. And then upon recovery of sorry, upon knowing that you are a HIV patient, it will be a grant for them to deny you that job. So I want to ask, first of all, is it right for an organization to request for an applicant's health status to be specific HIV status and then um, discriminating on that basis? I don't know if actually is in line with this particular data protection in when I'm with regards to the discrimination part, but I just want to ask. Thank you.
Okay, thank you very much for that question. The thing is, you would have known before now that what I said earlier was that data are usually collected, to help an organization achieve a particular purpose, right? To help them achieve a particular purpose. So wherein, like you said, they've given an option that if you are positive, HIV positive or not, and then on that basis, you are discriminated upon, right? That's the area you can, if you so wish, you can take it up. But then I don't really think in my own little view, I don't really think it's actually wrong for them to have asked you to provide your HIV status, right? It will only be wrong, or it will only be an issue. It will only be an issue if, having given that your status to the organization, and they now leaks it to a third party, and that has now brought you some sort of disrespect, some sort of discrimination from the outside now. That's when you now have, as per the this you have given, that's when you can now hold that, okay, they've actually violated the data you have given them, at least in line with what we've just learned now. But then again, discriminating you solely for the reason that somebody is HIV positive is actually not a good ground which you can take it up legally. But then, as per asking you to provide your information, your HIV status, in my own humble view, I don't think there's anything wrong in asking, so long as this information you have so given is saved with them, is not shared with the third party, without your own consent having had and obtained, that they've not violated, from the concept I've just studied, they've not violated any privacy law. I don't know if that answers the question.
Yes, sir. Yes, sir. Thank you so much.
Thank you so much. Thank you so much. Please, we've come to the end of today's section. It's already 3 p.m. and the meeting is already have come to a close. Please, if you have further question, you can just follow him on his LinkedIn profile. You can also follow our firm on the LinkedIn profile. Drop your questions, go through the slides, you will be clarified. Thank you all for joining this wonderful section. And I'm so sorry we're not able to attend to everybody's question. We're really, really sorry about that because the topic is very broad and there was no time at all. So see you guys next time. Take care of yourselves. Bye.
Please, was the second class cancelled? I thought we had a second class. Was the second class cancelled?
I think you should probably send another link for that because I don't think it's the same link we're using. I guess.